The sentencing structure for crimes are set forth in the state's specific penal law statutes or their criminal law statutes. So each jurisdiction has its own set of laws and punishments. So New York will have theirs, Connecticut, Vermont, California. They all have their own statutes that sets forth what the penalties are going to be for a particular crime. The federal court system has something sort of similar. They actually have a sentencing structure. It's a very complicated set of guidelines, and it's actually in volumes of books. So it's not a matter of, in other states, like the state of New York, you can look up the crime. It'll tell you that it's a Class A, Class B, Class C, Class D, E felony, or whatever misdemeanor it might be. And then once you know that, you can look under what's the punishment for a Class A felony, and then there's a category for violent and for non-violent. So you can look it up. It's fairly structured and easy to find. The federal court system, extremely complicated. Some crimes do have their own mandated sentence. We're going to talk about mandatory sentence momentarily, and that will be stated in a statute. Otherwise, there is this voluminous book that sets forth the structure for sentencing, and the case that still allows for the judge to have some sort of discretion is the United States versus Booker, and that will be mentioned a little bit later in this discussion. So the basic gist of each of these systems is either to set forth, even though they each have their own system, each jurisdiction has its own criminal law, body of criminal law with its appropriate penalties, including the federal system. It is generally broken down into indeterminate sentences, determinate sentences, and mandatory sentences. And that's really going to depend on the crime. So let's talk about indeterminate sentences. Indeterminate sentence, they're created to kind of fit an individual's needs, right? Gives the court discretion. It's wide ranging. It also allows the correctional facility to determine whether or not rehabilitation need to happen. How does it work? The terms of incarceration are stated in minimum and maximum length. And generally, an offender is eligible for parole or early release, when reaching their minimum. This is not automatic. The Department of Corrections will decide release based on rehabilitation. They go before a parole, someone goes before a parole board for that determination. So let me give you an example so you can put it in the context. Grand larceny in the 4th degree in New York State is a Class E non-violent felony. Okay? Crime that would constitute a grand larceny in the 4th degree would be stealing a car, stealing a credit card, taking something of value worth over $1,000 or more. Should a court choose to sentence someone to prison for this conviction, the indeterminate sentence, I'll actually read you the statute, and then we'll put it together. An indeterminate sentence, somebody convicted of this crime, having a maximum term of not less than 3 years and not more than 4 years, and a minimum term of not less than 1 year and not more than 1/3 of the maximum term. Therefore, this is what it would look like. Therefore, the least such sentence is 1 to 3 years. That would be a indeterminate sentence. A court saying your sentence is 1 to 3 years. It's a range. And the greatest, based on this statute, that a court can impose on grand larceny in the 4th degree is 1 1/3 to 4 years. That's the maximum. It could have a middle. There could be a middle ground. It could be 2 to 4. That's a middle ground. Burglary in the 3rd degree, breaking and entering with intent to commit a crime therein. That is also a felony. It's a Class D felony, so it's the next higher level up. The indeterminate sentence, it's considered nonviolent, is having a maximum term of not less than 3 years and not more than 7 years, and a minimum term of not less than 1 year and not more than 1/3 of the maximum term. So a court can impose, the least sentence the court can impose on this is 1 to 3 years, and the greatest such sentence is 2 1/3 to 7 years. And the court has a wide range of options. The court can say 2 to 4 years, 3 to 6 years, using that window set forth by the statute. And the offenders are confined until rehabilitated, where they can be released under supervision, i.e. parole, for the remainder of the time. These indeterminate sentences are generally for nonviolent felony crimes. At least that's the structure in New York. Generally, they're for nonviolent felony crimes. It gives a window, allows for rehabilitation. That's an indeterminate type of a sentence. There's a minimum and there's a maximum. A determinate sentence. These are fixed terms of incarceration, and they were kind of aimed at controlling judicial discretion. They're more geared towards violent felonies or serious felony drug crimes. Some believe these sentences are too restrictive for rehabilitation, but on the other hand, the offender knows how much time he or she's going to serve. There's not this, well, my minimum, if I'm sentenced to an indeterminate sentence of 1 to 3, I may get out in 1 year, I may get out in 2, I may have to serve the whole time. It depends on what correction deems as rehabilitated, what types of programs, what types of charge, and I've seen lots of people be denied their release. There is a video I want you to consider as we talk about determinate sentences. It's the sentencing of Jose Torres. It was a hate crime in Georgia. And the question I'm posing is, do you think that was a harsh sentence? So you'll have to go and watch the video. But let's talk a little bit more about determinate sentences. Let me give you an example. Assault in the 2nd degree in New York State means assault in the 2nd degree with intent to cause serious physical injury. That is the crime. And the judge can impose a determinate sentence according to the statute, because it is a violent crime to commit assault, serious injury. Example of a serious injury was somebody lose a limb. Right, they were stabbed, had to go to the hospital. The determinate sentence of imprisonment says between 2 and 7 years. This is not a window, a minimum of 1, a maximum of 3. This is not a window. This is a guideline for the court. So the judge can say, Mr. Smith, sentencing you to 2 years for the crime of assault in the 2nd degree. He could say 4 years, he could say 7 years, he could say 3.5 years. Can't say 8 years, and cannot say 1, because the statute set forth the minimum is 2 years and the maximum is 7. I'm not going to use the term mandatory here because there are other things the judge can do outside of prison. There could be a probation sentence and there could be a local jail sentence, but we're talking about prison sentences, and assault in the 2nd degree carries prison sentence. Criminal possession of a weapon in the 2nd degree. Let me put it in context for you. A person is guilty of criminal possession of a weapon in the 2nd degree when, 1, with intent to use the weapon, unlawfully against another, and such person possesses a machine gun. or other loaded weapon. That's criminal possession in the criminal possession of a weapon in the second degree. And a person who is found guilty of that crime can be sentenced to a determinate sentence. And the statute sets forth, and it says must be in whole or half years, between 3.5 years to 15 years. That's a big window. Judge can do 3.5, judge can do 4, can do 5, 6, can do 15, can do 14.5. That's the range. Can't do 16 and can't do less than 3.5. That's the range. Now, does this mean every time an offender commits an assault second, this is the range the court has to work with? Let's say we have a repeat offender. Let's say we have a man who beat up his neighbor for stealing tools from his shed. The court sentences the man to 3 years. Okay? And 3 years later, he is out, and he's been stewing the whole time about this case. And we'll also say that during that time, this man's wife left him for the neighbor. And now the wife lives with the neighbor next door, right? And the man's back at his house. And now he's been out, and it's a couple months later, and he can't take it anymore. And he sees the neighbor out washing his car, and he goes over and he beats him up again, putting the guy in the hospital. And this man is now arrested the second time around for assault in the second. Does the judge have that same window of 2 to 7 years? The judge has to work with that sentencing structure. We have a repeat offender. Clearly he has some anger issues. Now he's got a criminal history because he's got a prior assault. No, the court can take into account that prior felony conviction. And according to the repeat offender statute, the judge's window is now 3 to 7 years. So it's up a little bit. So in some, when someone becomes a repeat offender, they face an increased sentence of time. As I mentioned earlier, sentencing guidelines relative to federal sentencing. The states do not have a manual called sentencing guidelines like the federal court system has. The state has guidelines for determining the appropriate sentence that's set forth by the specific statute or penal law. And the key is guidelines. The key here is guidelines. When there is no mandatory sentence, which we'll talk about in a moment, the court has discretion. And the court has to consider areas that we just talked about: deterrence, incapacitation, retribution, rehabilitation, restitution, as well as the background of the offender and, characteristics of the person and criminal history. So in that instance, the judge has a different window, and the window is higher as a result of that individual, in my example, being a repeat offender. So we talked about indeterminate sentences. We talked about determinate sentences. Let's talk about mandatory sentences. And I am going to direct you to a website that is also under the additional materials to look at the effect of mandatory sentences on individuals. Let's talk about what they are. It is a statutory required penalty that must be imposed and carried out upon conviction. And this is just another way of curbing judicial discretion, as well as getting tough on crime. And there has been a flood of mandatory sentencing statutes in federal crimes, specifically the drug crimes. Let's get tough on crime. In essence, it was to stop drug trafficking. There's mandatory sentences in drug crimes, gun crimes, kidnapping. It takes a lot of discretion away from the court system when there's a mandatory sentence, and it gives lots of power to the prosecutor. The prosecutor is the one that formulates the charges, and they can do that based on sentencing. If they can see a charge where they can get a mandatory prison sentence, it requires the offender to spend time in prison. before being considered for any sort of release. And this could be someone who's never committed a crime before, depending on what that crime is. So this is a lot of control for the prosecutor. Let me give you an example. Criminal possession of a controlled substance in the 3rd degree. In New York State, it's a Class B felony. And let's say our controlled substance is cocaine. The sentence, the statute says the sentence must be a determinate sentence of imprisonment. So there is no wiggle room. There is no, oh, well, maybe we'll give him probation, or maybe we'll give, a lesser, maybe we'll do a treatment program, which in some cases might apply. But the statute says if somebody is convicted of criminal possession of a controlled substance in the 3rd degree, they must be sentenced to prison. And that term must be between 1 and 9 years. And in addition to that, so the judge would have to at least impose 1 year. Could impose 2, couldn't impose 3, could impose 4, can't impose 10. And can't say, no, I'm just going to put him on probation. Has to impose prison. And it's a determinate sentence. And on top of that, the judge is required to impose parole supervision after the fact of between 1 and 2 years. Could be 1 year, could be 1.5 years, could be 2 years. So after the judge, picks the range, let's say 2 years, I'm going to sentence this person to 2 years for the crime of criminal possession of a controlled substance in the 3rd degree. The court must also impose an additional at least 1 year of parole supervision. These are mandatory terms. And if the person violates their release, their supervision, they go back to jail to serve that time. So that's a lot of penalty as a result that may only be a one-time thing, a one-time possession of, cocaine. Arson with a person present in New York State, 2nd degree, determinate sentence. It's mandatory, 5 years. Mandatory minimum 5 years. You set fire to a person's house and somebody is in it or could be in it, 5 years. That's the minimum. 25 is the max. So there is a lot of discussion regarding mandatory sentences and the effect of people, especially the drug crimes in federal court, because a lot of folks are just drug users. They're abusers. They have a problem. They're not necessarily, they're the middle people between the big traffic guns in those cases. So take a look at that website to see, the impact of mandatory sentences on not only people, the offenders, but on their families as well. I represented a young man who was only 25 years old, who didn't have the best life growing up, and he had already had, I'm probably going to have this example come up again. He had already had 2 drug felony convictions from the state of New Jersey on his record, and he was on probation. At the time, he decided to get on a bus and take it from New Jersey to New York with a backpack full of heroin, only to be picked up by the feds. And already his sentence at that point was going to be mandatory with the amount of heroin he had on it. But the fact that he had 2 prior felony drug convictions, they didn't have to be federal. They could have been from any state, but they were felonies, enhanced his sentence significantly. For someone who's never done jail time, because he was on probation for those 2. Had never been to jail to get a significant mandatory jail sentence. So that's the effect of these mandatory sentences. The idea was, I'd imagine, to get the big guns, but in doing so, you end up getting folks that probably should not be spending that much time in prison. So, can courts enhance a sentence. Courts are not allowed to willy-nilly enhance a sentence without there being some sort of finding of fact from a judge. Enhancing a sentence is based on factual circumstances. I talked about this under the Eighth Amendment discussion earlier in the semester, and it's worth noting here again. It's on page 22 in the book, Blakely versus Washington. Assault in the second degree. Let's take that again. With intent to cause, right? When you assault somebody with intent to cause serious physical injury, right? This is not a mandatory sentence. Court has other options, like I said. Probation, could be local time. But here we're discussing prison sentence, so that's what we're going to work with, okay? And as I said just a moment ago, it's a determinate sentence the court must impose, and the minimum is 2, the maximum is 5. Remember our neighbor example above? So let's take the court's enhancing power, okay? If a defendant is convicted of assault in the second degree as a hate crime, the sentencing options are the same for a violent felony. So let me put this into context. Let's go back to that neighbor example. Let's say the neighbor, the offender is Caucasian and the neighbor is African American. To make my example a version of a hate crime. The same facts. I'm going to use the same facts, okay? Unless the prosecutor presents the case to a jury as a form of a hate crime, and hopefully you have watched that video that I indicated shortly ago, what is an example of a hate crime, meaning the prosecutor has to prove beyond a reasonable doubt that the defendant did what they did, acted the way they acted towards the victim, was fueled by hate, then the court can use a higher sentencing guidelines. And in New York, that assault second, rather than it being 2 to 7, would be 3.5 to 15 years if the district attorney proves that the case was a hate crime. Now let's say none of that information came to light. It was just he beat up his neighbor. And none of the information regarding the offender being white and the victim being African American, with the exception of you seeing them testify in court. But the prosecutor never says anything during the trial and never tries to try that fact or points that out. But then when sentencing comes along, the prosecutor says, oh, by the way, judge, this was a hate crime. And the judge imposes a higher sentence. That can't happen. That can't happen. That's what I mean by enhancing the sentence based on factual circumstances. It just can't happen. The jury has to be able to find that fact beyond a reasonable, guilty of that fact beyond a reasonable doubt. That's an example of the court's enhancing power. Blakely versus Washington. The United States versus Booker. Well, before I get there, I want to do one more thought on the Blakely versus Washington. So we talked about when the court can enhance, but can the court also decrease a sentence based on facts proven at trial? As well, they have to be proven at trial. Same example above, the neighbor. Except let's say our defendant is a wife that has been subject to years of abuse and finally breaks and attacks the victim, who's her husband. Same example, except let's say that our defendant is now a wife, and after years of being abused by her husband, finally breaks down and attacks. All right, now she's charged with assault in the second degree. There is a statute in New York, domestic violence. If domestic violence by the victim, i.e. in this case the husband, against the defendant, wife, was a factor in causing the defendant to commit the instant offense, the court may, in lieu of imposing a determinate sentence, can impose an indeterminate sentence. And that's our 1 to 3 years or 1 1/3 to 7 years. Is that a decrease in sentence? It sure is. Indeterminate. The other one is flatbed. It's a flat with mandatory parole. So yes, the court has power to decrease the sentence as long as the jury finds that particular fact. Okay? And obviously it would be, in this case, think about it, this would be the defendant raising it as a defense, saying that she was subject to domestic violence. This would not be something the prosecutor would have to prove. So the key in proving the fact of a hate crime beyond a reasonable doubt. For the defense, in this instance, preponderance of the evidence. You got to remember those differences of burdens, the burden of proof. The court can't just assume it and can't find out about it at sentencing. So United States versus Booker. This is, as I said, the federal court. This is a federal case. United States Supreme Court. The guidelines were under attack. That volume of federal guidelines that were put into place, taking a lot of discretion away from the court. And the Supreme Court said those guidelines are merely guidelines for the court to follow. There is still a number of discretion issues involved. Here's what they are. The court lays them out, and basically they are those five modes that we talked about earlier: the deterrence, the incapacitation, etc. So that's what United States versus Booker says. The guidelines in federal court are always under attack, trying to give more discretion to the courts, especially relative to the drug cases and the mandatory drug rules. I believe my slide just before this mentioned the 3 strikes laws. I want to talk about it now. It kind of gives the court some more enhancing powers, courts in general. Most states provide a lengthy prison term for anyone convicted of 3 or more felonies. And I'm going to say it's easier said than done. Usually 1 or more has to be a violent felony crime for the law to be applied. Courts are required to hold a hearing at the prosecutor's request to seek such a sentence. And most 3-strike laws, if it gets past that hearing stage, are 25 to life. And research shows that this is not very effective. Why would you think it's not very effective? By the time you get your 3 strikes, these defenders are probably getting too old for crime. They're already a chronic violent offender facing lengthy sentences already, and they particularly don't care one way or another. The Supreme Court has said that the 3 strikes rule is constitutional and not against a violation of the 8th Amendment. In New York, the 3 strikes rule is called the persistent felony offender. And basically it's an indeterminate sentence of imprisonment. The maximum term must be life, and the minimum term may not be less than 12 years and no more than 25. So the least sentence is 12 to life, and the greatest sentence is 25 to life. And it doesn't particularly matter what your felonies are. You can have 2 prior assault cases, felony cases, and then the third one could be a burglary or an arson. They don't have to be related. And when I told you the story about the young man who I represented, just to play that one out here for the sentencing, the 3 strikes sentencing. Federal court also has a 3 strikes law, but in particular relative to drug cases, if somebody has at least 2 prior felonies, drug felonies, regardless of whether they're federal or state, not only can the court enhance the sentence that they're about to impose on a felony, a 3rd felony drug case pending in federal court, that they can also deem the person what's called a career criminal. And once a federal judge deems somebody a career criminal, that's the warning. It's kind of a warning sign that, and the judge will also say it. The court will also say, and because I am deeming you a career criminal, first I'll ask whether they know what that means. And the answer should be yes, because their attorney should have told them, because it won't be a surprise. An attorney will know it's coming. Is that if they are again convicted of a federal felony drug offense, then they must be sentenced to 25 to life. That's what happens. So, all right, sentence modes. Let's talk about imposing those sentences. In considering its sentence, the court will hear from the victim or victims. There's more than one. The court will also hear from the prosecutor. We'll also hear from defense counsel. And by law, the defendant is allowed to make a statement. And they can talk as long as they want. This is their moment. There's a judge locally that says, this is your moment to shine. I don't know why he says that, but he says that. The probation department will prepare a report, whether it's in federal court or in state court. The probation department, from the time the individual is convicted, either they've pled guilty or there was a trial and there was a guilty verdict, to the time that is scheduled for sentencing, the court directs the probation department to prepare a report. They interview the defendant, they do an investigation, they compile criminal history, social background, employment history, educational history, military background, and the family background, and just the overall character of the defendant. These reports can be as little as a couple pages to voluminous, depending on the offender. So the court will have a large amount of information before it when it imposes its sentence, because the judge has to look at those 5 factors when handing down a sentence, along with following the stated punishment in the relative or the related statute for the penalty, as we just talked about, whether it's an indeterminate sentence, determinate sentence, mandatory sentence. When there is more than one sentence involved, meaning the defendant's convicted of more than one crime, or the defendant is either currently serving a sentence, or under the supervision from a sentence, like they're on probation when they had committed the new crime and were found guilty, or they were already in prison. Offenders can commit crimes while they're in prison. The most common one is they're possessing something they shouldn't have, like a shank. The court is going to have to determine how those sentences affect each other. And sometimes it's guided by statute. But we have concurrent. The court can impose the sentences to run concurrently or consecutively. Concurrent sentences, they are served simultaneously. Court imposes a 3-year sentence on a conviction for possession of a controlled substance. And let's say there was a fight, and there was also an assault, and let's say so there's a conviction for assault second, and the judge imposes a 10-year sentence on the assault second to run concurrently. The offender serves 10 years, right? I should have said 7 years if we're going to use the New York statute. So let's go back and redo my example. Because I told you this, the sentence for assault second in New York State is 2 to 7. So let's say the court imposes 3 and the drug charge, possession of a controlled substance in the third degree is between 1 and 9 years. So let's say the judge imposes on the drug charge 3 years and 7 years on the assault and says I'm going to run those concurrently. He doesn't have to, by the way, even though they stem from the same incident. They are 2 different crimes with different elements. So the judge can technically impose them consecutively, but concurrently they are served simultaneously. So the maximum time that this individual can serve is 7 years. Right? The 3 is served within the 7. And consecutive sentences are when they're stacked or they're back to back, one right after the other. So if the judge said, and you have to serve those consecutively, the 3 and the 7 would go back to back for a total of 10 years. And by law, in New York State, by law, sentences are served concurrently unless the court imposes otherwise, or if provided by the law, because sometimes the law will say this sentence must run consecutive to any other sentence, and that's usually if somebody is on probation, they're already serving a sentence on a crime, or they're in prison, they commit a crime in prison, the charges the sentences will run back to back or consecutive. There's good time. It's called merit time in New York State. And that kind of, the purpose of good time, it exists everywhere in the federal system as well. And what would be the point of good time? Right? It helps to enhance cooperation in the prison, right? People want to get out. If they didn't have like a motivation, i.e. good time, then they could give a whole lot of gruff to corrections. Right, but they can earn good time, and they can earn early release to parole, especially if they participate in programs that might be available. The good time, it ranges from 10 to 15 days per month. In New York, it's 7 days. You got to serve 2/3 of a month. 2/3 of a month. Of course, on the other side of that, they could totally lose those good time benefits if they misbehave or get into trouble, get returned to prison if they were released early. Right, they have to go back to parole or go back to prison because they were released early to parole and they violated. So all of those things affect good time, and that concludes this discussion regarding sentencing modes. Our final topic is going to be how are people sentenced. We'll probably spend a significant amount of time talking about capital punishment in that segment as well.